now resumed.
Good morning. Just before the province gets underway, I wanted to deal with the ruling on the motion by Canada dated November 4, 2011. On Friday, November the 4th, 2011, Counsel for Canada, supported by Counsel for the Province and Counsel for the BC Salmon Farmers Association, asked me to rule that the following paragraphs be struck out of the written reply submissions made by the Conservation Coalition, the Aquaculture Coalition, and the Healthsick Tribal Council. 1. Conservation Coalition, paragraphs 19, 33, 34, 35, 40, 41, and recommendation J. 2. Aquaculture Coalition, first two sentences of the second paragraph on page 4. And 3. The Healthsick Tribal Council, paragraphs 23, 24, 25, and 26. The Counsel for Canada challenged these paragraphs on the basis that they referred to facts, not in evidence, relating to the possible presence of the infectious salmon anemia ISA virus in several Pacific salmon. The paragraphs were said to be prejudicial in that the submissions would be posted on the Commission's website and would therefore be available to the public. I have now reviewed the challenged paragraphs. Some of the identified paragraphs in the submissions do make reference to media releases on the ISAV issue, which are not in evidence. The submissions of the Conservation Coalition and the Healthsick Tribal Council expressly refer to the fact that these media releases are not in evidence and urge the Commission to take steps to put the supporting documents and information into evidence. Reply submissions were due by 4 p.m. on November 3, 2011. At the end of the day on November 3, 2011, Commission Counsel advised all participants that the Commission plans to convene a 2-day hearing in mid-December to put new information about the possible presence of the ISA virus in British Columbia on the Commission's record. As such, the Commission's intention with respect to the treatment of the new information on the possible presence of the ISA virus in British Columbia was not known to the participants at the time they submitted their reply submissions. To the extent that statements in the submissions make reference to facts not already in evidence, these statements appear to be based on information already in the public domain. As such, I see no harm in allowing the submissions to be placed on the Commission's website in their present form. The submissions themselves are not evidence, and to the extent the submissions rely on facts not in evidence before this Commission, such submissions will not be entitled to weight. Participants will be able to further address the ISAV issue when hearings on the issue are convened in the future, at which time evidence will be brought into the Commission's record. Therefore, the reply submissions of the Conservation Coalition, the Aquaculture Coalition, and the Healthsick Tribal Council may be posted on the Commission's website in their current form. And I will now ask the province to step forward.
Good morning, Commissioner. Boris Tyzik, appearing for the province of British Columbia. With me are Clifton Prowse and Tara Callan. We have 90 minutes. I will focus on the terms of reference, the Aboriginal right to fish, and related issues and recommendations. Ms. Callan will deal with aquaculture and diseases. Mr. Prowse will deal with related evidentiary topics and concluding remarks. Initially, I will refer to our written submission of October 17, 2011, pages 12 to 17. Thereafter, I will turn to our reply submission of November 3, paragraphs 2 to 35 to deal with the Aboriginal right to fish and related issues, and conclude with our written submissions at pages 20 to 26. And Mr. Lyon, if you could bring up the written submission of October 17th at page 12, please. First of all, the province would like to thank the Commissioner for granting the province standing and the opportunity to participate in this federal inquiry established pursuant to the Inquiries Act. The province has cooperated with Commission Counsel throughout these hearings. A number of present and former provincial employees were interviewed, and a total of 12 present and former provincial employees testified before you. In addition, the province has disclosed a significant amount of relevant documentation as requested by Commission Counsel or pursuant to your rulings. We think that the Commissioner has succeeded in conducting an inquiry that has, in most respects, encouraged broad cooperation amongst the stakeholders. To that end, we commend the Commissioner, Commission Counsel, and the various participants. The evidence shows that the sockeye fishery contributes to the provincial economy. The preliminary estimates from the 2010 run indicated that the landed value of the sockeye fishery was approximately $90 million, and the Fraser River sockeye fishery contributed significantly to that total. Mr. Commissioner, I will be using the term interest or interests in my submissions, and I use this term in the broadest sense. We are not equating one interest necessarily with another. Many groups, often with varying interests, are involved in the Fraser River sockeye fishery, including First Nations, commercial fishers, recreational fishers, and environmental groups. The federal government, and more particularly the Department of Fisheries and Oceans, is charged constitutionally with managing the fishery. All of this makes the management of the fishery more challenging, yet this points to the need for all parties who have an interest in the Fraser River sockeye fishery to work together for the common goal of having a sustainable fishery now and for future generations. This theme of an inclusive fishery and the involvement of all interested parties in the management of the fishery, with the federal government as the central authority managing the fishery, will be expanded upon in the province's discussion of suggested recommendations. I'll now turn to the first point, which is the mandate issue at page 12. Actually, Mr. Lynn, if you go to page 14, is that this is a federal inquiry. And the terms of reference clearly focus on the policies, practices, and procedures of DFO. Therefore, any recommendations from the Commissioner should focus on DFO and other federal departments as required. At pages 15 and 16, we have the terms of reference. And item B notes that the Commissioner is to consider the policies, practices of the Department of Fisheries and Oceans with respect to various aspects of the sockeye salmon fishery. Item C requires you to investigate and make independent findings of fact, and Mr. Proust will deal with that matter in his submissions. And D directs you to develop recommendations for improving the future sustainability of the sockeye salmon fishery in the Fraser River, including, as required, any changes to the policies, practices, and procedures of the department. Clearly a focus on DFO. That the focus of the inquiry is the federal government was evidenced in the Habitat and Management hearings, where on April 4, 2011, Commission Counsel stated the following at pages 44, lines 40 to 46. As you appreciate, Mr. Commissioner, this is a federal commission of inquiry, and the terms of reference obviously and in particular focus on DFO and the federal government. As will be apparent, and in particular in this PPR number 8, the focus is very much on DFO and the federal government. The terms of reference do not ask you to consider the policies, practices, and programs of the provincial government or to make any comments on that. It's not surprising. This is a federal inquiry commissioned by the Governor and Council. Therefore, we submit that given the terms of reference and their focus on DFO policies, practices, and procedures, your recommendations should be directed at DFO and, as necessary, other federal departments. Our second point deals with the Aboriginal right to fish. Mr. Lunn, if you could turn to our reply submission in paragraphs 2 to 35. Our second point concerning the Aboriginal right to fish concerns the various recommendations made by First Nations participants that, in effect, ask you to make findings with respect to Aboriginal rights and title or the scope of the Aboriginal right to fish or recommendations in relation to that. Our position is as follows. There is no mention of Aboriginal rights and title in your terms of reference. Secondly, this is a very complex and controversial area of the law, and this commission is not the proper forum to make any findings or rulings concerning Aboriginal rights and title or make recommendations that Aboriginal rights and title be recognized. Thirdly, we say that there is settled law which the Commissioner can turn to with respect to considering the Aboriginal right to fish. At paragraph 3 of our submission, we refer to your interim report of October 2010 at page 9, wherein the following is stated. The legal landscape within which this commission operates has changed as well. This change will require a consideration of the Aboriginal right to fish under Section 35 of the Constitution Act of 1982, as well as other things. The province admits that this consideration of the Aboriginal right to fish should not go so far as to include making any specific rulings or findings with respect to the scope of Aboriginal title, the Aboriginal right to fish, or with respect to treaty rights, or with respect to any particular First Nation. We refer to paragraph 4 of our written submission of October 17, or sorry, page 18 at paragraph 4, where we comment on the fact that your terms of reference do not include any reference to Aboriginal rights and title, and the fact that this is not the forum to do so. We would also note that in submissions of Commission Counsel on October 25, 2010, when we were considering PPR number 1, the following was stated. Commission Counsel agreed that although your terms of reference do not direct you to make any findings of Aboriginal rights and title, that an overview of this area of the law may be helpful in providing contextual background for the factual information yet to come. In paragraphs 5 and 6 of our reply submission, we also submit that you should not make any recommendations with respect to requiring DFO or the federal government to recognize Aboriginal rights and title. Because in our view, in doing so, you would be making implied findings of fact that there is indeed Aboriginal rights and title, or on the scope of that. And we say at paragraph 7 that it would be inappropriate for you to do so given the nature of the forum and the fact that the testimony has come solely from witnesses chosen by Commission Counsel, or exhibits including the paper Exhibit 1135 submitted by Dr. Harris, and we will refer to that in more detail later in our submissions. At paragraphs 9 to 13, we note certain general observations about the law concerning the Aboriginal right to fish and fisheries in general. Paragraph 9, we refer to the NICAL case and note the need there for a balanced approach. As the court said in referring to the decision of the Ontario Court of Appeal in R.V. Agawa, the exercise of rights by an individual or group is limited by the rights of others. Rights do not exist in a vacuum, and the exercise of any right involves the balancing of interests and values involved in the rights of others. On this theme of balance, in a number of the submissions, reference was made to the Aboriginal perspective. We note the comments of Chief Justice McLaughlin in the Mitchell case where she said, placing due weight on the Aboriginal perspective means that such evidence be given equal and due treatment, and further that evidence from Aboriginal claimants should not be artificially strained to carry more weight than it can reasonably support. At paragraph 11, in dealing with the fisheries in general, we note the comments of the Supreme Court of Canada in the Como Seafoods case, which PPR 1 alludes to at paragraphs 31 and 32, where this is stated: Canada's fisheries are a common property resource belonging to all the people of Canada. And this is a theme which we incorporate in our recommendations, Commissioner, where we suggest that the fishery be inclusive and that all interested parties be involved in the management of the fishery. Finally, with respect to the management, we note this comment about the need for a central authority to manage the fishery. And in the NICAL case, the court said this: if a salmon fishery is to survive, there must be some control exercised by a central authority. It is the federal government which will be required to manage the fishery and C, to the improvement and increase of the stock of that fishery. At paragraphs 14 to 17, we refer to the state of the law and take issue with various submissions of the First Nations participants. We identify some of those aspects in paragraph 16, and we ask that you consider those later. In paragraph 17, we set out our view that the various First Nations submissions provide little authority for many of the positions put forward as to the state of the law, especially on the scope of the Aboriginal right to fish. Having said that there is a lot of controversy in the area, we say at page 18, Commissioner, that there is settled law which you can use to consider the Aboriginal right to fish. That settled law includes the following. Aboriginal rights are fact-specific and First Nation-specific. Number 2, the Aboriginal right to fish is not a property resource, nor does it convey any ownership in the resource. And again, cases are cited for this. Number 3, there has been no recognition of quantifiable levels of harvesting or sale. Number 4, there has been no recognition of jurisdiction over a right to manage a fishery in the context of limiting or determining the action of others, including non-Aboriginal fishers. 5, there has been recognition of aspects of internal self-regulation of fishing by Aboriginal communities, as described in the Nical case. And 6, the components for the test for Aboriginal rights are clearly defined. I refer to the Vanderbeek case, and there are others. I would note the recent Court of Appeal decision in the Ahousaht case when dealing with the issue of costs, where our Court of Appeal commented that there were established legal principles in regard to Aboriginal rights and that cases were fact-driven. The court referred to the trilogy of cases, Vanderpeet, Gladstone, and MTC Smokehouse, as providing the legal framework for trial decisions in both the Lax Kw'alaams case, which is we're awaiting a decision in the Supreme Court of Canada, and the Ahousaht case, where leave has been sought to the Supreme Court of Canada. It is interesting to note that in the Lax Kw'alaams case, the court found that there was no commercial right to fish, whereas in the Ahousaht case, the court did find that there was a right to sail, albeit not on an industrial scale. At paragraph 21, we submit that PPR number 1, the Aboriginal and Treaty Rights Framework underlying the Fraser River sockeye salmon fishery, subject to the caveats the province set out in its written submissions of October 19, 2010, and our oral submissions of October 26, 2010, sets out in general a fair, accurate, and balanced description of the existing law, and we submit that that can be used by the Commissioner to consider the Aboriginal right to fish. We do have some concerns about the more speculative aspects of PPR number 1, and we mention those in paragraph 22 of our reply submission. In paragraphs 23 to 26, we highlight aspects of PPR number 1, including paragraph 36, which refers to the fact that Aboriginal rights are held by specific groups and can vary amongst the groups and are highly fact-specific. We also note paragraph 43 of the PPR, which states it as follows. An Aboriginal right to fish, for example, is the right to the practice, custom, or tradition of fishing, the verb, as opposed to the right to fish, the noun. This interpretation is supported by the court's finding that although an Aboriginal right to fish may protect a traditional means of substance or pre-contact practice that was relied upon for survival, there is no such thing as an Aboriginal right to sustenance or the right to the fish themselves. We set out examples of specific concerns we have to the various submissions of a number of the First Nations participants, and we leave those to you to review. Because a number of the First Nations submissions, including those of the First Nations Coalition, the West Central Coast Salish First Nations, the Stolo Tribal Council and Chim Indian Band, and the Healthsuck, refer to Dr. Harris's paper and use it as evidence to support their claims for Aboriginal rights and title, or as a basis to make recommendations, we have set out our concerns about the paper. Our main point is that the paper should not be used as a basis for any findings of fact or rulings. We note that Dr. Harris is a respected academic, and his paper does provide useful background on the various aspects of regulation of Aboriginal fisheries. However, the Dr. Harris paper was prepared at the behest of Commission Counsel. It was not tendered as a legal opinion, nor did Commission Counsel tender the paper as an opinion or an interpretation or application of domestic law to the facts discussed in the paper. We refer to our objections with respect to the Dr. Harris paper concerning Indian reserves in particular in our written submission of October 17th at page 18 and our cross-examination of Dr. Harris on June 27th at pages 23 to 33. Dr. Harris did not make any reference to the leading Supreme Court of Canada cases in Nical and Lewis, and we feel that this is a serious, if not fatal, flaw to his evidence. Therefore, Commissioner, getting back to the comment in your interim report that you needed to consider the Aboriginal right to fish, we feel that PPR number 1, subject to the reservations that we have noted, provides you with a basis to do that. Having said that, it is clear from the evidence that First Nation witnesses provided that First Nations have a long history and an interest and connection with the Fraser River sockeye fishery. Further, DFO is involved in many consultations with First Nations with respect to fisheries and fisheries management. How First Nations should be involved in the management of the Fraser River sockeye fishery is a matter for which there has been considerable testimony. One of the issues that DFO faces, we submit, is how to have effective and efficient consultation with First Nations and involve First Nations in fisheries management, given the complexity of the fishery, the number of First Nations involved in the Fraser River sockeye fishery. We have heard estimates of 130 or more. And those have varying interests, be they the intercept fisheries, the lower Fraser fisheries, or those further upriver. However, we say that there are other groups who also have interests in the Fraser River sockeye fishery, including commercial fishers, recreational fishers, and non-governmental organizations. And we feel that these should be involved in the management of the fishery. Our recommendations 2, 3, and 4 are based on this theme that the fishery be inclusive and the management of it include all interested parties. Mr. Lunn, if you can turn to pages 21 to 26. Recommendation number 2 we have is that the DFO continue support for the ISDF process. Exhibit 392 that was put in provides a framework for the Integrated Salmon Dialogue Forum. It was a multi-party process involving representatives from First Nations, commercial fishers, recreational fishers, NGOs, DFO, and the province had some representatives there. Wayne Sato on February 3rd commented on the value of the ISDF process and indicated it was an opportunity to hear from all interested parties and attempt to reach consensus before making policy decisions. The witnesses on the May 12th panel, including Grand Chief Ken Malloway, Peter Sakich, the chair of the Commercial Salmon Advisory Board, and Colin Masson of DFO, all expressed support for the continuation of that process. Grand Chief Malloway, Mr. Sakich, and Mr. Masson also agreed with the description of the ISDF process at paragraph 18 of PPR 12, where as a collaborative and inclusive opportunity for all interested to work together towards a fully integrated, sustainable salmon fishery. Another recommendation we have deals with the monitoring and compliance panel, which was one of the panels that was formed out of the ISDF process. On a number of occasions, we have heard various witnesses talk about trust in each other's numbers. And this is a key part of what the monitoring and compliance panel was aiming to achieve. There was support on the May 12th from the panel members, again, Grand Chief Malloway, Mr. Sakich, and Mr. Masson for the continuing work of the monitoring and compliance panel. Mr. Masson specifically said this at page 73, lines 5 to 12. I am a full supporter of the monitoring and compliance panel. It's only really begun to scratch the surface. I think that I have a vision that this group could do more, and we have touched on that today. I think it's really useful for the department and the resources for participants. And we note that Exhibit 429, which was DFO's strategic framework for fisheries monitoring and catch reporting, was based on the work of the Monitoring and Compliance Panel. And Exhibit 855, we refer you, Commissioner, to that exhibit and the strategic approach at page 12 and the summary at page 14, is that the fisheries management process for the Fraser River should be inclusive and include all parties who have an interest in that fishery. If you go to the next, there, Miss. We would adopt the comments of Joseph Becker, a member of the Musqueam Fisheries Commission, in his testimony of December 13, 2010, when he stated, "Fish are the responsibility of everyone who participates in the fishery." He went on to say that all user groups should be involved in a management regime so that there will be fish for the future for our grandchildren. Later we note going on at pages 24 and 25, some examples of third-party processes. The fourth submission we have, Mr. Commissioner, is that DFO carry out its action plan with respect to certification of pursuant to the MSC process. The testimony of Rob Morley emphasized the importance of MSC certification to Fraser River sockeye. That's number one, Mr. Lund. The draft surveillance report, Exhibit 1993, reported on the status of, in general, that the MSC, the surveillance report stated that some conditions have been met, others are expected to be met within 2 years. The analysis of some conditions is deferred, and that some additional action of DFO is required for other conditions. Given the importance of MSC certification to the economic viability of the sockeye fishery, it's crucial that DFO fulfill these commitments as set out in the action plan, and therefore the Commissioner should include in his recommendations the need for DFO to fulfill its commitments under the action plan. Our last recommendation, and Mr. Lund, if now you go to page 26, this is number 5, is that the federal government should consider new fisheries legislation. It's be on page 26. This is a matter which is included as part of Canada's business plan, which is Exhibit 1930 at page 11, which just says bringing forward a new Fisheries Act. PPR number 3 sets out an outline of what happened with the last 3 bills that went forward. No doubt the federal government would consider recommendations from this commission with respect to proposed legislative or regulatory change. Finally, Mr. Commissioner, any recommendations you make, we submit, should be practical and implementable. Thank you. Now Ms. Cowan will make submissions on aquaculture and diseases.
Mr. Commissioner, I will be addressing the topics of aquaculture and disease on behalf of the province. The province will start its submission with a description of the former program, will outline the inspections conducted and the programs that were funded by the province. I will then discuss the diseases that Dr. Kent considered high risk. I will then rebut the issues raised by the Aquaculture Coalition, including their disputes with the disease incident numbers, infectious salmon anemia, plasmacytoid leukemia, and Dr. Miller's genomic signature. I will set out that the evidence in these proceedings does not support the Aquaculture Coalition's position on any of these issues. Farmed salmon comprises 39% of the total value of seafood exports from British Columbia. It's worth approximately $348.1 million in 2009 and directly and indirectly creates 6,000 jobs. And this reference is from page 18 of the Aquaculture PPR So paragraph 18, page 12. Prior to the transfer to the federal regime, the province regulated aquaculture and conducted frequent inspections. It conducted between 110 and 120 fish health inspections per year. It conducted sea lice audits of 25% of all active farms per quarter and 50% of all farms during the period of outmigration, and also conducted an annual compliance audit of each farm per year. The province was also interested in improving the program where it could, and in doing so conducted regular reviews of its program. Some of these programs included the Gillespie Report, the Salmon Aquaculture Review, and the Special Committee for Sustainable Aquaculture. The province also looked at ways to make the industry more sustainable. One of these was closed containment systems. In supporting it, it funded several projects to do so. And if we could turn to page 87 of my submissions, it'll set out the number of projects that the province ran. Marine Harvest's Salt Spring Pilot and the Namgis First Nations Land-Based Atlantic Salmon Recirculating Aquaculture Systems Pilot Program, which is still ongoing. While it's too early to tell if closed containment is going to be viable or not, the funding and the work conducted by the province materially moved the state-of-the-art forward. I'll now move on to the subject of diseases. Dr. Kent provided a report on diseases that he thought could impact sockeye salmon. As a result, he subjectively identified 6 diseases he thought posed a potential high risk to sockeye salmon. The incident levels of these 6 diseases at salmon farms were reviewed by Dr. Noakes. Dr. Noakes noted that the farms vaccinate against most of these diseases. In cases where the fish are not vaccinated, the incident levels along the outmigration route were low and were unlikely the cause of the long-term decline in productivity and were unlikely the cause of the poor 2009 run. The Aquaculture Coalition takes issue with a number of mortalities from disease. At page 6 of their submissions, the Aquaculture Coalition submits that approximately 10% of salmon in the net pens die, and most of that is from disease. The province disagrees with this characterization. The province does agree with the Aquaculture Coalition in that the number of fresh silver mortality should not be used as the calculation for the numbers of fish which died from disease. Fresh silver fish are simply normal-sized fish that recently died. There are many causes of death that could have occurred that have nothing to do with disease, although they are, of the various categories of group, more likely to have disease than the other categories of group of fish. This issue is raised with the Project 5 panel. All of the panel members agreed that the category of fresh silvers does not properly identify fish that died from disease, and that there could be many other causes for their death. There were other categories as well that the Aquaculture Coalition thought should be included in the disease mortality calculations. Those were older fish mortalities and poor performers, as well as environmental or predator deaths. With respect to the older fish mortalities and poor performers, Dr. Corman gave evidence that he didn't think it was fair to say that all old fish or poor performers died of disease, and that would be from page 19 of the August 29, 2011 transcript. With respect to environmental or predator deaths, they should not be included in the total as well, because the cause of death was presumably identified, so death should be established to be from either predation or environmental conditions, and therefore would unlikely be from disease. One of the complaints that has been levied against or by the Aquaculture Coalition is that the province was only measuring mortalities. It is of import to mention that the farm veterinarians were monitoring diseases on a daily basis. Dr. McKenzie in particular testified that he looked at behavioral changes in performance, and this would be from the August 31st transcript at pages 17 to 18. That's right, starting at line 44. And Dr. Mackenzie testified, on top, as the strictly pure veterinarian, my role, again, is to manage disease. So I do a lot of analysis on disease, monitoring disease on all our farms and hatcheries, looking for changes, looking for trends, looking for identifications or deviations from what I consider normal, and he says normal again, fish health. And then if we go on to line 8, last two words, and I would add that my clinical experience where how the fish are behaving, how the fish are performing, what I'm seeing grossly on a necropsy and other tests we may take into house, other laboratories, other steps. So he's clearly not just looking at mortalities, he's looking at behavioral changes as well. I'll now move on to the topic of infectious salmon anemia. Anemia is a potential cause of the decline and relies upon nonspecific symptoms of sinusodal congestion in Dr. Marty's pathology reports to implicate the fish farms. It, however, ignores the PCR tests that were conducted on each of these farmed fish, which were all negative for infectious salmon anemia. These results are summarized at Exhibit 1471, if Mr. Lund could turn to that. This document shows that 4,726 PCR tests were conducted on BC farm fish, and all were negative for infectious salmon anemia. The Aquaculture Coalition's position also ignores the fact that the province also looked at the recent mortality patterns on the farm and conducted histopathology to look for lesions as well. Now, Dr. McWilliams, who's an expert on infectious salmon anemia, says it does not cause disease in sockeye salmon. The Aquaculture Coalition denies that infectious salmon anemia testing is sufficient, saying at page 22 of their report, or of their submissions, that there is currently no formal testing program for infectious salmon anemia on BC fish farms. In the reference footnote, it says, proper testing requires 50 fish per facility. That is not done. The province disputes that while they had conduct of the program, that the testing was inadequate. It says that the difference of numbers of fish required for testing goes to the type of sampling that's being conducted. The Aquaculture Coalition was referring to a random sampling of 60 live fish. The province used a different methodology that increases the chances of finding diseased fish. Rather than a random sampling of 60 live fish, most of which would be expected to be healthy, the province sampled the dead, fresh silverfish. In Exhibit 1567, the document on which the Aquaculture Coalition relies for this assertion, this type of testing was also considered an appropriate method. Dr. Mackenzie, on the August 31st date of testimony, testified on this point and opined that it was a robust program. And specifically, it's page 56 of the August 31st transcript. And I won't go through the entire section, but it can be read by the Commissioner at a later time. Mr. Lunn, if we could now turn to page 25 of the province's reply argument. So at this point, we're going to be moving on to the hem lesion. This is one of the two lesions that the Aquaculture Coalition says is one of the symptoms of infectious salmon anemia. One of the two lesions that they listed was hemorrhage or congestion of the kidney, and in Dr. Marty's records, it's described as the hem lesion. The province says this lesion is a non-specific lesion that can occur with post-mortem change. Specifically, as fish decompose, pooling of the blood or congestion occurs in the kidney. The graph on page 25 of the province's reply argument looks at lately autolysis, which is liver decomposition and is found at column 5 of Exhibit 1676, and grafted against the severity of the hem lesion from Dr. Marty's records. As decomposition after death increases, or the time increases, the severity of the hem score also increases, and that's what this graph is trying to show. As such, one must be careful not to attribute microscopic findings or concrete findings of disease without first considering how long the fish has been dead. My last point on infectious salmon anemia is with respect to a comment that the First Nations Coalition said in the reply argument at page 33. They seem to say that Dr. Dill's opinion regarding what is suspect case of ISA should be given weight. The province repeats its position that Dr. Dill is not qualified, nor did he purport to be qualified, on diagnosis of fish disease or what's considered to be a suspect case of infectious salmon anemia. He did say that he has expertise in ecological considerations, but that the province submits is different from what we were trying to say in our argument with respect to what is a suspect case of infectious salmon anemia. I'll now move on to the topic of plasmacytoid leukemia or marine anemia. The Aquaculture Coalition raises plasmacytoid leukemia as a possible cause of the poor 2009 run, relying upon what they say is one diagnosis of plasmacytoid leukemia along the outmigration route. The province says that it was not plasmacytoid leukemia that was found at all, but it was rather another disorder called lomosamane. And this is based on a correct interpretation of the records. Even so, with respect to sockeye salmon, plasmacytoid leukemia has not been shown to cause mortalities in lab studies. And Exhibit 1488 is the record for that. In that, they noted that the sockeye at the end of the study appeared clinically normal, had histological lesions, but no mortalities. The Aquaculture Coalition says that plasmacytoid leukemia should be diagnosed anytime the ISH lesion, which is another acronym as well from Dr. Marty's records, is identified in a salmon. However, the scientific paper that they cited for this position, which is Exhibit 1491, page 421, which is the first paragraph under the materials and methods, lists 4 requirements for the diagnosis of marine anemia. Of these 4 lesions or requirements to support the disease, only the first one, which is hyperplasia of the interstitial cells of the caudal kidney, is tracked in Dr. Marty's database. And this is the ISH lesion. Because the provincial database only contains one of the 4 requirements for diagnosis, further diagnostic evidence must be considered before plasmacytoid leukemia can be diagnosed. Accordingly, tracking the ISH lesion is not an accurate measure of whether or not any particular fish has plasmacytoid leukemia. The province also submits that the ISH lesion is also associated with bacterial kidney disease and rickettsia, which are common diseases found in wild Pacific salmon. Counsel for the province, in the last 2 minutes of time, asked Dr. Marty to do a sort on his spreadsheet in Atlantic salmon to show bacterial kidney disease prevalence with the ISH lesion. On page 20 of the Aquaculture Coalition submissions, they indicated that the sorting on Pacifics creates an obvious and dramatic difference, and that there's no other reason for why ISH is severe and common in Chinook other than the relative difference in susceptibility. The reason why the sort wasn't done during evidence was simple. Cross-examination was very limited, and I was not permitted to ask the question as time had run out. Regardless, one answer regarding why interstitial cell hyperplasia of the caudal kidney is often more severe in Chinook salmon is that they are more susceptible to BKD. Additionally, in Appendix B of the Aquaculture Coalition submission, the ISH lesion is rarely the most significant lesion noted on the file, and likely therefore was not the cause of death. As a result, this line of submissions is without merit. I'll now move on to Dr. Miller's work. Dr. Miller has identified a novel genomic signature associated with mortality in certain conditions. This is preliminary work, and it's important work. The genomic signature, however, has been identified in smolts, so it's likely not caused by the salmon farms along the outmigration route, as the smolts are infected before they actually pass through any of the salmon farms. The Aquaculture Coalition has also argued that there are 4 additional exotic viruses apparent in Dr. Marty's records. Their argument says that Dr. Marty reported the lesions associated with salmon alpha virus, heart and skeletal muscle inflammation, cardiomyopathy, and a Chilean coho farm virus. As with all of the other diseases mentioned in my submissions, the Aquaculture Coalition fails to distinguish between symptoms and disease. The province again says this is the wrong approach to take and is contrary to the evidence at the hearing by the fish health experts. Dr. Kent testified on one of the salmon alpha viruses called pancreas disease and noted that it's never been confirmed in British Columbia. Dr. Marty testified on page 57 of the August 31st transcript and said that infectious pancreatic necrosis virus has not been diagnosed and all test results have been negative for the disease. And if we could turn to the transcript. At line 17, it starts, then we have exotic diseases that we don't have in British Columbia. One of them is infectious pancreatic necrosis virus, and all the tests have been negative for that, and they're listed here. The other virus is infectious salmon anemia virus. It is the most interest of these proceedings, and again, all the tests were negative for that. Now, with respect to heart and skeletal muscle inflammation, cardiomyopathy syndrome, and the Chilean coho farm virus, there's no evidence regarding diagnosis of these diseases. So, in conclusion, on the issues of aquaculture and disease, the province submits the way that salmon aquaculture is practiced in British Columbia with the addition of the regulatory regime that was implemented by the province and now is implemented by the federal government. It creates a low overall risk to the environment, and the disease incident data from the audits, as well as the Salmon Farmers Association database, shows that it's unlikely that aquaculture caused the long-term decline of productivity in Fraser River sockeye salmon or the poor run in 2009. At this point, I'll turn over to Mr. Prowse.
Cliff Prowse, for the record. So, in my submissions, I'm going to continue on. Then I will be going to deal with an overview of the issues from the province's point of view, a brief discussion of the other science issues apart from the disease and aquaculture issues that my colleague Mr. Collins just used, and then I will turn to a brief summary of some points from the areas where provincial witnesses were called, and finally I'm going to make some concluding remarks, including some analysis of the fish management tool, which was put into evidence very close to the end of the hearings as a result of some remarks made by Mr. Huang during the hydro and water hearings, when he referred to this tool as being something that had helped fish. So, Mr. Commissioner, Mr. Tyzik has highlighted the province's recommendations on the need for an inclusive approach to DFO consultation and management, reflecting the fact that fisheries continue to play an important socio-economic role affecting all persons in the province. He's also referred to case law, which amongst other things stresses the need for effective decision-making. The reliance on good science in making fisheries management decisions and other environmental decisions has occupied much testimony. The scientists have come from DFO, other governmental agencies, NGOs, consultants, and private entities working in the environment, and academia. This is related in our submission to the importance of what I would broadly call professional reliance, including professional reliance on third parties and their professional consultants. Ms. Callan, during the hearing and in her submissions, has dealt with the details of disease and fish health management in the aquaculture context. She has referred to the evidence that Dr. Kent and Dr. Corman, for example, relied on the disease specialists in their reports. Aquaculture has grown into a significant socioeconomic industry in its own right, but it's one that must be sustainable. To use David Bevan's term, it must demonstrate that it has earned a social license through active participation in monitoring for risks of disease and damage to wild salmon and the environment. My submission will continue to demonstrate that the evidence likewise shows that it's not likely that any of the provincial topics contributed to either the 20-year decline on a population basis or the 2009 collapse of the Fraser River sockeye fishery. It will also demonstrate the importance of professionals in preventing damage to the environment, a topic dealt with by provincial witnesses in the Forester hearing and also the riparian area regulation hearing. I will be highlighting the remaining areas of the province's submissions as well. Mr. Commissioner, in one of the participant submissions, in effect, a straw man was set up saying that in the province's submissions that we are claiming that the Fraser Basin is pristine, and of course the Fraser Basin covers approximately 40% of the province of British Columbia, and so it houses a lot of the socio-economic activity in the province and the place where we're speaking as we speak. So I don't think one could fairly call the City of Vancouver a pristine environment, and we don't do that. I think it's of some help to say what the province does do, and so I'm going to utilize here some language which I'll just read to you if I may. The provincial government uses ecosystem and watershed approaches to manage the land and water base for the sustainability of all natural resource components. So this goes broader than salmon and includes salmon, and to some extent one of the themes I think emerging from the DFO side is for some time has been that when you're looking at salmon, you also have to go broader to an ecosystem-based approach. So the province does not take a salmon-centric approach, and of course this inquiry by its mandate is directed to take that approach. So the province focuses on the sustainability of all natural resource components, including salmon, and our strategies, policy, and legislation are focused on the whole environment, not just a single species. In the long term, these broad approaches are hoped to prove effective mechanisms for protecting and sustaining salmon, and will serve as the basis for interaction with federal policy and program frameworks. The provincial focus has principally been on freshwater fish and freshwater habitats, and salmon considerations were and are taken into account as an important component of the freshwater ecosystem. The people of the province clearly have a vested interest in the wild salmon as an economic and socio-economic basis, and that includes clearly the First Nations with the interests that have been referred to throughout and that Mr. Tyzik acknowledged, as well as the other people of the province, including the various participants that are before you. BC has never had a direct role in managing salmon per se, where management infers responsibility for establishing production goals and allocations. No single piece of legislation has been developed to protect salmon as such, but there are different provisions to protect fish and their habitats, and these exist in a number of provincial resource management statutes, including the Water Act, the Forest and Range Practices Act, the Fish Protection Act, and the Environmental Management Act, formerly the Waste Management Act. Federal departments, particularly DFO, have been actively engaged in the development and review of this legislation and associated regulations to ensure consistency in the intent and equivalency of provincial measures with the provisions of the Fisheries Act and other federal legislation. So that's the framework that brings the province to this this hearing, and also the perspective that the province takes with respect to its legislation. And of course there was evidence from Lynn Kreiwoken and DFO witnesses about the current Water Act modernization initiative, where DFO has certainly taken an advocacy role and has interacted with the province and others in the broad-based consultation process that Ms. Krywogan discussed in evidence for you. To continue the overview of the provinces, I would ask you to turn to paragraphs 30 to 42 of the province's final submissions of October the 17th. So I'm going to read paragraph 30 slowly and say, Mr. Commissioner, that this is taken from the provincial response to the PPR. I think it's PPR 3, which dealt with the legislative framework, and it basically takes the role that I've just read to you and puts it into the constitutional framework. So the environment is a diffuse subject that cuts across many different areas of constitutional responsibility, some federal, some provincial. It is a constitutionally abstruse matter which involves considerable overlap and uncertainty. And I guess one can pause to note that a Morton decision was one that dealt with one of the overlaps and uncertainties. The principles of federalism and cooperative federalism include recognition that there is an inevitable overlap in rules made, and the task of maintaining the balance in practice falls primarily to governments. So there is the task of the governments is to minimize the extent to which federal and provincial regulations are saying different people to do on the same topic, and that's where difficulties will ensue. You've heard I summarize in paragraphs 31 and 32, and reflects the number of broad areas where the province is involved in regulating on the land and water base in ways that result in impacts on water, and obviously if we get into impacts on water, then it raises issues with respect to impacts on fish. The provincial witnesses came from different ministries, and if one of the things that happened during the inquiry is that several of the different ministries were tied into a new ministry, which I refer to as FLENRO, and mercifully we have never really explored what exactly FLENRO is, but we've had witnesses from that ministry and other ministries before you. So the witnesses include riparian areas coordinator, and her work has involved both the federal and local governments and professional associations, as well as the public and their professionals. 2 biologists with expertise on effluent monitoring, a water regulator working on a joint committee dealing with sediment removal applications for a provincial agency charged with public safety as the proponent. So in that case, Emergency Management BC, so a different ministry from the witness who was from FLENRO. A forestry scientist with broad experience, including the important long-running Carnation Creek project. A professional forester with an extensive history of work on forest planning and professional responsibility. A longtime water manager who is a professional engineer, and the director of the Environmental Sustainability and Strategic Policy Division for the Ministry of Environment, who has led public consultation on the Water Act modernization process. And Mr. Tyzik has referred to the evidence of Wayne Sato, who is somebody who gave testimony on the integrated planning processes and has a huge history in fish management. And Ms. Callan has also told you about the provincial witnesses, Dr. Marty and Dr. Shepard, who has in fact transferred from the provincial government to the federal government following the Morden decision. Mr. Commissioner, none of the provincial topics, individually or collectively, is responsible for the 20-year decline of Fraser River sockeye salmon or the collapse in 2009. And accordingly, the province generally does not make extensive discussions or submissions on the evidence, nor does it make recommendations, either with respect to matters of provincial jurisdiction, which we submit that on the facts before you are really outside of the Commission's mandate in terms of recommendations, nor in the circumstances of matters within federal jurisdiction, particularly matters of DFO budgets, policies, and practices. And in particular, we recognize that you and the other participants making recommendations to you are faced with the unenviable task of trying to sift through the huge amount of science evidence and the huge number of recommendations before you about expenditures on science and research, but we consider that it's appropriate for us not to participate in that discussion, given the role of the province in this commission and its role as a different government. Develop some themes or reflections. The first one is that the Commission hearings reflect a snapshot in time. As we've heard in your ruling this morning, obviously one additional matter will have that snapshot taken at a slightly different period, but all of these matters are and should be ongoing. So we're dealing with a snapshot in time, and there's work to be done in all areas, and the work needs to be ongoing, and that's part of an adaptive management framework, is in fact to continue to work to reflect back, and that's part of what the province does within the matters of provincial jurisdiction. The second thing that I think emerges from the evidence is that the 1990s were a time of active engagement and improvement in environmental matters generally, and there are key critical results in such areas as pulp mill effluents and forest practices, and the evidence before you establishes that those improvements in fact were improvements and did improve the environment and did improve the sockeye salmon habitat with respect to those things. The third thing that's evident from the evidence is that the 21st century has seen moves by all governments, but I suppose particularly the federal and provincial governments, towards a more streamlined, results-based approach to regulation. And I then say that this seems unlikely to change anytime soon, and that probably is something that the Commissioner will have to consider with respect to the ongoing work of the recommendations of the Commission with respect to the future, and the Commissioner and the participants will have to grapple with the practicalities of what is likely to be implemented. It may be helpful for the Commission to reflect on the framework that Mr. Taylor for Canada mentioned on Friday, which was that on the one hand, the work needs to be done and is being done and will be done on an incremental basis on the one hand, but Mr. Taylor on the other hand said that we also should be looking at the big picture or the long view, and it may be that recommendations that take those two different approaches may bear fruit, if not immediately, then in the longer term. The fourth thing I submit that follows as a theme from the different areas is that intergovernmental cooperation may not always work smoothly, and governments may not always see eye to eye, but in fact on the hearing panels that we had, my submission is that the federal and provincial witnesses on these topics generated good models of respectful cooperation. So I think you saw that in the evidence before you. And the last theme that I I refer to is that in terms of the topics in the hearings, we tend as lawyers to focus on problem solving and address ourselves to problems and to look at that sort of historic negative analysis and look back. But you are tasked with looking forward, and in our submission, we hope that it will be helpful for you to look at some of the success stories. So I refer in paragraph 41 to the enthusiasm about Paul Higgins about a particular dealing with, I think, a client of Ms. Gardner. Anyway, it made a marked impression on me, the enthusiasm that he talked about those dealings and that it was, in effect, transformative for him. I refer here to the SLIP project, which I'll briefly reference later, and I refer to the fish water management tool where there's ongoing work being done and dividends are being paid, where there's cooperation by First Nations and different levels of government and industry, and so all of the participants do have in our submission a role in the future sustainability of Fraser River sockeye salmon. I then want to turn briefly to a focus on climate change, and I think my submissions on this topic and the interweaving topic really of marine effects can be brief, because there is a significant amount of consensus, I think, that these are important factors. Some of the submissions point out that there are implications that need to be considered with respect to future sustainability, but I'm dealing with these primarily as a matter of the causal questions that you've been posed, and it seems to me that there is a consensus that climate change is an important part of that. Mr. Commissioner, the subject was well summarized in the testimony led by Commission Counsel and Direct on March 8th, and I won't take you to the references, but basically at pages 6 and 7, Dr. Hinch summarized the background information on climate change and the perspectives on it, including the importance of variability as an aspect of climate change, evidence about a general increase in air and water temperatures and marine oscillations. At lines 13 to 15, he notes that 13 of the past 20 years were record temperatures as part of the historical consensus about climate change. And at lines 20 to 25, he concludes that all the literature and modeling predicts these trends will continue. And I think in the broader public and broader discussion, there's ongoing questions about it, but that was his evidence, and I don't think it was challenged in these hearings. At pages 10 and 11 on March the 8th, he explains the sensitivity of sockeye salmon to temperature, the master biological factor for a fish, and the First Nations Coalition has pointed you to those same words in their submission. The subject was also well summarized in cross-examination by Mr. Blair, particularly at pages 11 and 12 of the transcript on March 9. Mr. Commissioner, the province's submission on the Healy article, Exhibit 1320, are found at pages 55 to 58 of the province's report. And this morning I think I will simply say to you that, and submit that the report does an excellent job of relating climate change issues to sockeye in particular, and independently arrives at very similar conclusions to Exhibit 553. The outlook for sockeye is challenging. On the other hand, we know from the record returns in 2010 and the returns that in 2011, which are better, I think, even possibly than the record as it stood in the exhibit showing the new graph, including 2011, that there are grounds for hope, and that the sockeye obviously is an animal that has a resilience, and so there is much to be done, but we submit that the evidence shows that climate change is very important with respect to sockeye salmon. And secondly, the evidence that's been summarized by Mr. Marmarick in his report, when taken with the evidence summarized by Ms. Callan, leads to the conclusion that the causes of the decline are not aquaculture and disease, regulated by the province in conjunction with DFO's regulatory powers under the Fisheries Act up to December 2010, and are not the freshwater ecology issues. Rather, the evidence points to global features, including marine ecology and climate change. Mr. Commissioner, I now turn to the individual topics of provincial jurisdiction, and these are dealt with in the concise summary, paragraphs 43 to 70. The province's recommendations about an inclusive approach emanate from the recognition of the benefits of a sustainable fishery that benefits all residents and starts with conservation of the resource. The Commission has called evidence on a wide variety of topics, including a wide variety of provincial topics. The province regulates activities on the land, but deals with DFO on many different areas. Protecting stream health and aquatic environment is a key policy direction for the province, which recognizes that water must be considered in land use directions. In the modern era, the province relies on results-based regulation and relies on professionals, including third-party professionals, to achieve these ends. The province obviously has an interest with the people of the province in the socio-economic benefits, and it's recognized that sustainability is important to that. So I'm going to make a few points about two areas, logging on the one hand and water on the other. But before I do that, Mr. Commissioner, I don't know whether you wish to take the break now.
Thank you very much.
The hearing will recess for 15 minutes.